Good evening, everyone. I'm Rakhi Gautam from greytHR, the moderator for this Parichay webinar session today. Thank you so much for taking out the time and joining us on this 90th episode of Parichay. Great, we have already done some 90 episodes in season 2. So thank you so much for being with us, in this journey for so long. And this is, of course, because of you that we have been able to build such a community of HR professionals, labor law experts who join us on these sessions and share their insights with us. So thank you so much for being here with us in this journey. And we hope to see you and your continued support in a long run in the coming years. Now, the topic for today is ensuring compliance with labor laws, best practices, and recent updates. So I understand this topic, of course, it's a topic which is very, very vast. And of course, there are many things that we'll also be covering at our end today. But in case, you have any more questions or you want to understand or, dive deeper into this, we will be sharing our speakers' details with you separately in our thank you mailers, which will be sent to you by next week. So if you want to connect with them directly, you would have an opportunity to do that as well. Now, I think we have the quorum with us to start the session. So for those who have joined us for the very first time, let me just quickly take you through the agenda. We will start, the session is divided in two parts. The first part is the presentation by our experts, which will then be followed by an audience Q&A. So audience Q&A is where time is all yours. You can start putting across your questions in the Q&A panel, which is available on your screen. You'll be able to type in your questions and we will take them up towards the end. Also, there might be some questions that you type in right now, which would eventually be covered in the presentation or the discussion that we'll have. It might be answered, but in any case, please feel free to add in your questions. And if there are any unique questions that we haven't covered before, we'll take them up towards the end. Also, the session is currently being recorded, so do not worry at all. We have got you covered. If you miss out on anything, if you have meetings, you have meetings planned in between the sessions, you can always come back to the recording and watch it later. How you can do that? You can do that by going to our official greytHR YouTube channel under the playlist Parichay. So this webinar recording will be uploaded there. So you can always go there and watch it later. Now, this is a live link. However, if you want to share it with anybody who you feel would benefit from this session today, you can share the live link with them and they should be able to join this session right now. Okay, so that was about how the session is going to be conducted. Now coming to the topic, which is, labor law compliance and ensuring compliance with labor laws, right? Best practices and how we can be compliant ready. So in today's fast evolving regulatory landscape, keeping up with labor law compliance is more important and more challenging than ever, right? So with new labor codes on the horizon, shifting legal interpretations and increased scrutiny from regulators, organizations must stay proactive to ensure compliance and avoid costly pitfalls, of course, right? And today in this session, we'll be covering 4 core areas, which will be an overview of key labor laws, compliance requirements and updates under these laws, common compliance pitfalls and how to avoid them, and best practices for audits and regulatory reporting. So now, who will help us do that? We'll have, 2 accomplished, fantastic experts joining us today. Mr. Niten Agarwal, Director at ASC Consulting Private Limited, and Mr. Deepak Joshi, Associate Director at ASC Consulting Private Limited. Thank you so much, Niten and Deepak, for joining us today. Now, for our audience, I would like to quickly take you all through their profiles. Niten Agarwal is a distinguished FCA with over 15 years of rich experience in finance and advisory services. He's a dynamic leader driving businesses expansion and market growth. His proficiency in strategic partnerships, international business operations, and regulatory compliance has been instrumental in establishing a strong global presence. With extensive experience in managing cross-border offices, he excels in financial management, optimizing business performance, and fostering sustainable growth. Thank you so much once again, Niten, for joining us. It's a pleasure to have you here with us today.
Thank you, Rafi.
Okay, another speaker who's joined us from ASC is Deepak Joshi. He's a chartered accountant with over 12 years of experience, specializes in regulatory compliance, business structuring, due diligence, and litigation support. With deep expertise in labor laws, he ensures businesses remain compliant with evolving regulations, and he oversees payroll, statutory registrations, and audits. His problem solving approach and regulatory expertise make him a key figure in the field of compliance. And I'm sure we are going to learn a lot from him today. So thank you so much, Deepak, for joining us. It's a pleasure to have you here as well.
Thank you, Rakhi.
Great. So now that the introductions are over and we know what we are going to be talking about, since there's a lot to cover, I would like to hand over the session to you now to take us through your presentations. And to our audience, as I informed, we will take your questions towards the end. So if you have any questions, you can add in the chat, which is there, Q&A options and Q&A option, and we'll take them up towards the end. Over to you, Deepak and Niten, to take this conversation ahead.
Thank you, Rakhi, once again for this, a warm introduction. And I also thank all the attendees who are joining with us in this session. And as you told, that today's session is about the labor law compliances in India. So, to be very specific, we are covering one area of the labor law compliances that is related to the payment of the wages. Since the word wage is used here, that is important from the employee perspective because it's their earning, and from employer's perspective also because they have to run their business and they have to more compliant. So from the both angle, we are covering this session, and without wasting any time, I will just jump to the presentation. Give me a moment to share my screen.
Sure.
Yeah, I hope my screen is visible.
Yes, Deepak, you can go ahead.
So during this session, we will see there are many areas in the labor law, evolution of the labor law, that how labor law has been evolved during the entire journey of this what I say, from pre-colonial era to this code of wages. And then we come to the constitutional background, and we'll just briefly touch upon these two areas, and thereafter we'll go to the labor laws applicable in India and the key compliances. And then we quickly jump to the law related to the wages, which includes the Payment of Wage Act, Equal Remuneration Act, and the Minimum Wage Act. And thereafter, in the second part, we'll touch upon the new labor codes and the code of wages, to be very specific from the new labor law perspective. Now, as far as the evolution of the labor law is concerned, we have segregated the evolution into the four categories. That is one pre-colonial era, then colonial era, post-independence, and the reforms which the government is going to make through new labor codes. Now, what is pre-colonial era? Pre-colonial era means since there were no legal framework of the labor law, the employment was on the caste based, and the economy was not an industrial economy. It was a very agriculturist economy, and there are discretion of the employers that how the employees can be used at their own will. So this era is specified where there is no law related to the labors. It is only an employer dominant era. Now coming to the second aspect or the second era, which is the colonial era. In the colonial era, the British rulers came to the India. They framed certain laws, and the first law framed by them was the Factory Act. And this act was not for the welfare of the employees, but it is merely focusing on the how to control the labors. So these two era, give us a lesson that how the labor law should be in an independent India. So when the India become independent, the law was promoted by the constitution. There are many articles which are related to the labor laws. And in the next slides, we also covering that constitutional framework. And the entire labor law structure in India is focused on the welfare of the employees. So after independence, when there is a requirement, to stabilize the employment and stabilize the employers. And there is also need to, control over the employer. Uh, the labor laws framed in a such a way that it should control the labor and to, encourage the employer to do the social welfare of their employees. Now, once we achieve this position, now the Indian government thought that there is a certain stage of the labor law. Now we have to make the reforms. And in those reforms, we are, covering all the new labor codes, and Government of India come up with the new labor codes in 2019. Although these labor codes are in midway, the certain state has not defined their rules, but we are progressing toward the new reforms under the labor laws. Now coming to the constitutional background of the labor law. So as you know, in India, any law should be backed by the constitution. The power given by the constitution should be utilized to frame a law. Okay. Now, how the constitution help in framing the laws? First, the fundamental rights. There are Article 14 and Article 16, which gives the rise to the equal kind of opportunities of employment in India without having any discrimination, and um, the equal kind of remuneration also. And there should not be any discrimination on the basis of caste, gender, or area, locality, or their resident status. Now, the second aspect of the constitution is directive principle of the state policy. These directive principle, as far as related to labor laws, Article 39, Article 41, and Article 42, what are these directive principle of state policy? These are the guidelines for the state government or the central government, that using these guidelines, you have to frame a law related to labor or any law. For the consideration of labor law, the Article 39, Article 41, and 42 is used. But these are the merely guidelines for the state or central government to incorporate or to define a law related to the labors. Now, in third point, we are covering the division of power. As you know, there are three lists of the division of power between the state and center. There is a one union list, there is a one state list, and there is a one third concurrent list. The labor laws are covered under concurrent list. Now it means that central government has power to make the law, as well as the state government has the power to make the law related to employment or labor in India. So now when these two governments are making the law, then which law will prevail? So as far as there is no conflict between the laws, each law is applicable in every state. However, where there is a conflict in the law framed by the state government or law framed by the central government, the law framed by the central government will prevail unless there is an assent by the President of India on the state government laws. So this is the broad view of the division of power, that who has the power to frame the law on the labors. Now, apart from this, there is a judicial activism in India also related to the labor law. And as all the labor and HR professionals are here in this session, they might be aware about the Vishakha judgment. The Vishakha judgment is, the basic guiding principle for the POSH Act. Before the POSH Act, there was a complaint of the sexual harassment at the workplace, and the Supreme Court of India has defined a guideline for the prevention of that harassment. And on those guidelines, this POSH Act has been framed. So these four are the pillars of framing, a labor law in India. So laws in India. So if I have to count the law in India, so there are many labor laws in India. More than 30 central laws are there, which are dealing with the labors. And apart from that, there are many state specific laws. So if there are 38 states, then you can understand the complexity of the labor law, that there is a certain central laws, there are certain specific state laws, and then they are overlapping on each other. Then how we have to comply all these with? See, if for your reference, there are many acts we have referred it, like Shop and Commercial Establishment Act. This is a very state specific act. If we go to the Employee Provident Fund and Miscellaneous Provision Act, it is a central act. Employee State Insurance, it is a central act. Now the Payment of Gratuity Act. Gratuity Act is a central act, but the power to make the rules lies with the state government. Minimum Wage Act. Minimum Wage Act is also a central act. However, the minimum wage can be fixed by by the state governments. So there is a distribution of power regarding the formation of the law and the implementation of the law. So how many compliances are there in all these laws? So we have, classified all the criteria of the compliances which a employer has to, mark in their checklist. First one is registration or license. Whether it is a state law or a central law, there are certain kind of registration. So for example, there is a PF, you have to obtain a registration. ESI, you have to obtain a registration. Shop and Establishment Act, Factory Act, you have to obtain a license from the state government. CLRA, Contractual Labor Regulation Abolition Act. BOCW, Building and Other Construction Worker Act. Interstate Migrant Worker Act. Standing Order Act. These acts, defines a person or a criteria to obtain a registration. For example, the Shop and Establishment Act. Any state, any establishment which is having a 10 or more employees, generally 10 or more employees in a state, that employer has to obtain a shop and establishment license. If a person is having a more than 20 employees, then he has to obtain a PF registration. Now, after the registrations, what are the compliances employer has to do? First compliance is periodic filing of returns. Now, returns can be classified into two categories. One is contributory returns and another one is non-contributory returns. Now, when I say contributory returns means there are certain amount of money needs to be paid to the government account by way of deduction from the employee or by the employer himself, like PF. In PF, there are two contributions like employer share and employee share. We are going to deposit into the government account. Similarly, the ESIs. However, where is a SND, a shop and establishment return? It is a non-contributory return. It is the only, giving information about the past 1 year or half year as per the state requirements. It is a return which will give you the details of the organization to the labor offices. CLRA, you have to give a valid information to the department that how many contractual employees you have employed, what kind of salary you are giving to them, and what are the employment condition related there. Now, PT and LWF. PT and LWF are also a very state specific acts wherein employer and employee share needs to be deposited with the government account. Similarly, the employment exchange return and the POSH return. These are only the informatory returns which we have to file to the Labor Ministry or the Labor Department. Employment exchange return, including that how many employees you have employed during the quarter. It is a quarterly return, so that's why I'm using the word quarter. And POSH. Under the POSH, we have to give information to the Labor Department that how many POSH cases has been reported in the organization, how they has been resolved, what is the status of ICC committee, who are the members of the ICC committee, etc. So these are the periodic returns for a regular employer who is employing a certain category of employees. Apart from that, now these are the very basic compliances which every employer is knowing, and they might be fulfilling all these compliances. But trust me, there are many more compliances. Like there is a statutory display. Now, statutory display means as per the law, you have to display certain content in your building premises. And this is, backed by the law also. For example, abstract of that. For example, minimum wage act is applicable on you. Then you have to affix a minimum wage act abstract in your premises at a conspicuous place where every employee can see that, yes, this is the act applicable on the company. Similarly, payment of the wage act, similarly, bonus act, all the acts you have to display on a conspicuous place. This is a compliance. And if it is not compliant, then labor inspector may take action against you. Now, the second most important compliance, name and number of the labor inspector. So you have to display a name and number of your local or the jurisdictional labor inspector at a place where each and every employee have access. Similarly, holiday list. So as you are aware that in National Festival Holiday Act, we have to give a annual declaration to the labor officer that these are the holidays which we are giving to our employees. So that list needs to be displayed over the conspicuous place. Similarly, the timing of the office. It is a night shift, it is a day shift. What are the working hours? It is 8 to 5, 8 to 6. What are the timings that needs to be included here? Similarly, there are statutory declarations also, which we are statutorily required to be displayed over a conspicuous place, like child labor. So the declaration contains that we are not employing any child in this premises. So this is a statutory declaration. We have to do that. And most importantly, the date of wage payment. The payment of wage, the date of payment of wage is very important for every employee, and an employee should know that on which date we are paying it. So that's why the law make it mandatory that we should display that this is the date on which you are getting your salaries or wages. Now, another compliance, although it is not in the form of filings, but these are the compliances which you need to make in your own systems and internally. And as and when the labor inspector or any labor officer visits your office, or they call upon the information from you, then these records must be produced before them to make that you are complying with the law or the formats and everything which are contained in the law. You are complying with all these provisions. For example, employee registers. Now, employee register consists of many things like wages. What are the wages you are giving to the employees? What are the categories of wages like basic, DA, allowances, everything? In that, there might be, since these all statutory records are state level compliances or the regulated by the state government, therefore the format for each state may be different, but broadly each and every compliance consists of similar nature. So employee register contains the detail of employees, salaries detail, date of payment. Wage register also consists of categories of employees and how you are paying the wages to the employees. Register of fines. Now, fine means a deduction which is empowered by the law. So you can't deduct anything from any salary of an employee. So if you are deducting, then you have to make a register for that. This fine we have imposed on any employee, and due to this reason. Now, if there is an accident in an organization or in a factory, then you have to maintain a record of the register accidents. Similarly, the register of contractors. So if you are hiring a certain contractor on for manpower supply, then you have to maintain a register defining the name, nature of work, nature of employees, what kind of work they are doing. So this kind of register you have to maintain, and this is the requirement under CLRA Act. Now, 1, 2, 3, and 4. These 4 are the regular compliances. However, there are certain event-based compliances also. So these compliances can be undertaken or should be undertaken only when the event takes place. For example, there is a national festival holiday. So as per the National Festival Holiday Act, if an employee is supposed to work on a national holiday, which you have declared to the labor officer, then you have to give an advance notice to the labor inspector that these much of the employees are coming to the office and our office is operational during this national holiday. So if the employer, not complying to this event-based compliance, then the penal provisions may be invoked by the labor officers. Similarly, PF, when a new joiner joins, then there is a one event-based compliance, then you have to give a nomination forms, you have to add into the portal. So these are the basic event-based compliances which you have to take care. And last one is dispute resolution. So we can't assume that any organization doesn't have any dispute with the employees. So disputes may be there, but it is the responsibility of the employer to make the records of those disputes and to make the records that how those disputes are being resolved. Like in POSH, there is a given framework for the POSH compliances. Like if there is a complaint, then how ICC has to take it up, how the internal committee has to take it up, what are the kind of discussions you have to take with the aggrieved. You have to make the proceedings of the, the POSH proceedings of this entire, POSH compliances. So that is all the category of compliances. So we need to take care all of the compliances, not only the registration and periodic filings. Since many of the employer are taking care of the registration and periodic filings, they missed upon all these rest of the 4 compliances. And later on, when the labor officers visit the offices, then those employers will get penalized due to the penalty or something. Okay, so now we come to the next topic, law related to the wages. So law related to the wages, we are covering here 3 category of laws. One is payment of wage act, minimum wage act, and equal remuneration act. So first we are covering payment of wage act. So payment of wage act comes from very historical event that many employers are not giving a salary to their employees and they are just giving something in kind. So to curb on this practice, the Indian government introduced this payment of wage act with some additional objective also, that the time for the payment of wages is fixed. The nature of deductions from the wages is also fixed. And if someone have any grievances, then when those grievances can be raised to the government authorities. So we'll just briefly take you through the important feature of those this act. So first of all, this act is applicable to the employees drawing wages less than 24,000. So any employees is getting less than 24,000, this act is applicable on it. So what is the meaning of wages? So how we calculate this 24,000? So it includes salary, allowances, bonuses, but exclude the statutory deduction like PF, gratuity, and any statutory fines, or any order by the court for the deduction of any amount from the employee's salary that needs to be deducted from the wages. Now, what is the responsibility of the employer? The responsibility of the employer is to give the timely wages to an employee. Now, what is the meaning of timely payment of the wages? So law defines here that if an organization having less than 1,000 employees, then the wages should be paid before 7th of the next month. Or if an organization having 1,000 employees, then the payment can be made on or before 10th of the next month. Mode of the payment can be cash, check, or directly credited to the bank. However, in many states, the government has notified that it should be directly paid into the bank of the employee. Now, What is the authorized deduction? We have discussed in the wage definition that there are certain deductions can be made from the salary of the employee. So what is those deductions? So deduction means fines. Fines means anything which is, supported by the law. It should not be any arbitrary. For example, if a person is doing a work and that work goes wrong, and due to that wrong work, the employer has to bear certain expenses, that expenses cannot be deducted directly from the salary of the employees. So these are non-statutory fines. So we can deduct only the statutory fines from the salary of employee. If an employee is absent from the duty, then you can deduct the salary of that employee for that absent period. If you are giving a certain accommodation facility or you are giving a certain advance salary to the employee, you can deduct that from the salary. Similarly, the PF, taxes, ESI, or any employee contribution, you can deduct it from the salary directly. Now, what is the maximum deduction you can deduct from a salary? So, for example, if an employee having a salary of 10,000 and he has taken an advance from the employer of say 20,000. So when that, repayment of that advance become due, then employer cannot deduct the entire 10,000 in the one year. So that is the one relief which this law has given to the employee because to considering the fact that employee has to run his house for family and everything. So that's why the law gives a limit of 50% of total wages. You cannot deduct more than 50% of a wages from a single month salary. And if it is a cooperative society, then you can deduct a 75% from the salary of that month. Now, sorry. So if an employer make any default in making the payment of an employee or deduct anything which is not authorized by the law, then employee can file their claim to the authorities appointed by the government, but that claim can be made within 12 months of the event. So you cannot file a comment as an employee, you cannot file a claim beyond the period of 12 months. Now coming to the penalties, if an employer, commit any non-compliance under this act, then the penalties may be 7,500 for maximum 7,500 for the first offense. And if it is a second offense, then the penalty may be 10,000 or imprisonment for 1 to 6 months. Now, how many records needs to be maintained under this act? First, muster roll, wage register, deduction registers, overtime register. So these are the many registers which we need to make under this act. So this is all for payment of wage act. Now we'll quickly move to the minimum wage act, minimum payment of wage. So the objective of this act is to give a minimum salary to an employee who is working with an employer. So to organize this entire structure of minimum wage act, the government has to decide what are the scheduled employments. Earlier, there were certain categories of scheduled employment which are given in the schedule to this act. But now in current scenario, there are many other new categories has been included, and shop and establishments are also included in the scheduled employment. So any employee working under a shop or any establishment, then these minimum wage act is applicable on it. So who is the authority responsible for making these laws? The central government or the state government as applicable to the employer. So what the government will do, government will fix a minimum wage on the basis of category of employment, means whether it is a skilled employment, unskilled employment, or a semi-skilled employment. And secondly, the government fix the minimum wage on the basis of the region also. The how how it's worked, like government or the state government divide the state into 3 or 4 zones: zone A, zone B, zone C, zone D. And on the basis of those zones, the government fix a minimum wage. And the component of the minimum wage are basic salary, dearness allowance, and in some state government, there are other allowances also. And some government, state governments has also given a holistic, this is the minimum wage. So if there is a component of the minimum wage, then employer has to ensure that the wage should comply all the component of the minimum wage. It should not be like that holistically we are giving more than the minimum wage. The component of the minimum wage should also comply with the provisions of the Minimum Wage Act. So working hours, 9 hours usually, and one day you have to give a rest. And if an employee is working in off days or working after the working hours, then he has to give a overtime. And ordinarily, this overtime will be the double of the ordinary wage rate, which employer is giving to its employee. Okay, now we come to the Equal Remuneration Act. So this act is applicable to all of the establishment. And the purpose of this act is to ensure that there are equal salary to the both the genders, male and female. And moreover, it's not about the salary, it's the employment opportunities also, like in promotion, like in employment itself. You cannot discriminate between male or a female employee. You have to take them at par for each and every work. So what does equal pay means? Equal pay means if a male or female is working in similar circumstances with similar category of work, then there should not be a variation between their salaries. There should not be discrimination between their working condition, and there should not be any discrimination on the basis of gender. Now, from employer perspective, employer has to maintain certain records of minimum pay, what kind of pay they are giving to their employee, what category of the employees they have, and are they compliant with the Minimum Wage Act or not. And from the employee perspective, employee should be aware about that. What is the minimum wage he should be getting from the employer? So this is for Minimum Wage Act and the new labor codes. So for taking up this new labor code part, I invite Niten to take this up the session and enlighten us with this new labor codes reforms in new era. Yeah, over to you, Niten.
Thank you so much, Deepak, for the insightful information. I believe now we all have a fair understanding about the existing labor laws prevailing in India. Good evening, everyone. We have reached a key part of today's session. As we all understood from Deepak, the labor law framework is very cumbersome and is a complex web of numerous legislation, each catering to different needs of the employee-employee relationship and industrial relation. There is definitely a need to revamp the complete labor law legislation, and today we will try to understand the basis on which the upcoming reforms have been built. Just let me start with a quick story. In 2002, the government has formed a committee to look into the issues with the existing labor laws. The committee came with a conclusion that these laws are old, confusing, and too many, and there is definitely a need to make them simpler. Within the period 2015 to 2019, the government had talked with numerous companies, employers, states about to find a resolution to this kind of cumbersome issues. And after multiple round of discussion, finally in 2019 and 20, the Indian Parliament passed four new labor laws, also called labor codes. 29 separate legislations have been subsumed in the four comprehensive labor codes. The first code being the Code of Wages, wherein the four acts have been subsumed: the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. Similarly, the second code being the Industrial Relation Code, wherein the three codes have been subsumed: the Trade Union Act 1926, the Industrial Dispute Act 1947, and the Industrial Employment Act 1946. The third code being the Code on Social Security Wage, wherein 9 acts have been subsumed, importantly being the Maternity Benefit Act 1961, the Payment of Gratuity Act 1972, and the Employee Provident Fund and Miscellaneous Provision Act. The last but not the least, the Occupational Safety, Health and Working Conditions Code, when the 13 acts have been subsumed, the important being the Factories Act 1948 and the Contract Labor Act 1970. You can see that these 29 acts have been subsumed in major codes, and each of these codes addresses a core pillar of the employer-employee relationship. Today, we will focus on the first, the wage code, because it's impact every business, every employee, and every payroll system within the organization. Before jumping into the important feature of the wage code, first we need to understand why there was need for this reform. What made government think that definitely there should be reform into the existing labor laws? The majority being a single premise needs multiple registrations, maybe 5, 6 registrations under different laws. The word wages had different definitions under each act. PF was calculated one way, gratuity the another, and bonus was the third, bringing a lot of challenges to the HR system of the organization. Companies were filing multiple returns, maintaining multiple registers with largely the same information. And worst of all, the unorganized sector, which constitute 90% of the workforce, was largely outside the ambit of the old laws. To counter these issues among many, new reforms have been proposed. Now, what will be the objective of this new reform? What issues this new reform is going to address under the wage code? First, it is going to bring uniformity in the wage definition. This wage shall be utilized everywhere for the computation of maybe gratuity, computation of bonus, or maybe computation of the pay, ensuring fair and equal pay, regardless of gender and employment type. Extension of protection to all the workers. Every worker in the organization will be treated at par. Ease of compliances through digitized returns and registers. And finally, building a transparent tech-enabled framework that supports both growth and governance. We would also like to understand what will be the new code offered to the companies. The new code will be offering standardized definition. In the existing labor law structure, the definition differs in every act. So it will be providing a unified definition of wages that will apply across PF, bonus, gratuity, leave encashment, etc. If excluded components like HRA and bonus exceeds 50% of the total, the excess is counted back into the wages, covering 50% in the definition of the wages. And herein the definition of employer, establishment, contractor, contract labor, everything has been defined and has been standardized. In the new labor code, the government has also defined the national floor wage. The national floor wage will be determined in the central government. That is, the central government will fix and limit below which it will not be permissible to make payment to the employee. The state government has the right to make the changes into this slab, but yes, they cannot go below the slab that has been determined by the central government. They also ensure gender neutral pay protection, that all the employees, whether it's a male, female, or any other gender, will be treated at par in the organization and will be paid on the basis of quality of work that they will be doing in the organization. One unified return. From multiple returns, the company will be filing a single return, and universal applicability. The code applies to all employees, whether in organized, unorganized, supervisory role, managed role, all the employees will be covered under the ambit of the wage code. Now, let me take you through the important features of the wage code. First of all, applicability. The wage code will be applicable to all the employees, irrespective of the gender or wage limit. It will be applicable to all establishment, including factory. So herein, what government has tried to done is that the government has included all the employees. Also, they have included all the establishment, whether it is a trading concern, manufacturing concern, or it is a service industry. All the employees and all the companies will come under the ambit of the wages code. In respect of bonus, the government has stated that if any establishment is having 20 or more employees in during the any time during the accounting year, then bonus will be applicable on those companies. As already stated, the definition has been standardized. The definition of wage, employer, establishment, worker, accounting, contract labor, everything has been standardized. There is a uniformity in the definition that will be used in all the four codes that has been proposed. Time limit for the payment of the wages has also been defined. If the company is hiring employees on daily basis, weekly basis, then they need to make them payment as per the guidelines that has been defined under the law. For daily basis, the payment has to be made at the end of the shift. On a weekly basis, the payment has to be made on the last working day of the week. For fortnightly basis, on or before the second day from the end of the fortnight, and for the monthly basis, on or before the seventh day of the next month. So earlier there was no defined timelines wherein the payment was supposed to be made to the employees. Now government has defined the timelines within which the payment has to be made to the employees. So government has also introduced the concept of the wage floor, and the wage floor will be fixed on the basis of the minimum living standard of the worker. This will be basically fixed by the central government in consultation with the state government. So what does exactly this wage floor means is that the central government will be fixing a slab below which there will be no payment made to the employees. Floor wage can be single floor for the entire country or the different floor wages or depending upon the geographical locations. State has the power basically to change the floor wage, but they cannot reduce with what has been defined by the central government. After the initial fixation, the wage floor shall be revised every 5 years and the wages shall be revised every 6 months. Calculation and eligibility of bonus will also be determined and fixed by the government. As of now, there is no clear understanding how this computation will happen or what will be the eligibility criteria. But one thing has been defined that if any employee has worked in an organization for more than 30 days in an accounting year, he shall be eligible for bonus. The rate of the bonus has also been defined, that is 8.33% of the eligible wage or INR 100, whichever is higher, thereby ensuring at least 100 rupees bonus to the employees. Disqualification has come from the existing laws wherein the employee will be disqualified from receipt of the bonus in case there is any fraud, writers or violent behavior within the organization, theft, misappropriation, sabotage of any property to the establishment. Recently, conviction for the sexual harassment has also been added as a disqualification for bonus. So any employee who has been convicted for this issues, then definitely he will be disqualified from receipt of the bonus from the company. The another important aspect that has been covered in this wage code is that the contractor payment. Payment to contractor shall be ensured by the company before the contractor makes a payment of wages to his employees. In the earlier regime, the contractors who were providing contractor labor to the companies were making payment of salary to the employees from their pocket before receiving the payment from the employer or the company. Now the government has assured that any contractor who is providing the contractual labor will first receive the payment from the companies and thereafter he will be making payment to his employees. In the earlier slide, we have seen that the government has specified the period of 7 days after the end of the month to make the payment to the employees. So if 7 days the deadline to make the payment to the employees, then definitely the contractors will be receiving the payment before the 7th of the every month. So this is a kind of a protection that has been given to the contractors in this particular wage code. The next slide is wage settlement in the removal, resignation, dismissal cases. In case there is any employee who has been resigned or in case he has been removed from the organization, then the settlement has to happen within 2 working days. In the present scenario, there is a lot of challenges wherein an employee leaves an organization because the company takes a lot of time to conclude his full and final settlement as per the policies of the company. Sometimes they take 15 days, 30 days, 45 days, 60 days, totally depending upon the policy of the companies. But this has been determined that now the all the settlement will happen within 2 working days. Equality, this is what we have discussed as well, that there will be no discrimination in respect of gender, work in matters related to wages, recruitment of employees, and conditions of the work. From the inspection perspective, the government has introduced a new concept, that is the inspector cum facilitator. The inspector cum facilitator will play an administrative role, like he will be inspecting all the records maintained by the company, and he will also play a major role as an advisor to the company. The ICF also has the power to initiate the prosecution against the company in case of any non-compliance. But yes, before providing any kind of prosecution, he will provide an opportunity to rectify the error. If error is rectified, then ICF shall not initiate the proceeding. But in case the rectification is not made on a timely manner, then definitely the prosecution will happen against the company for the non-compliance. The important charge has been given to the ICF in the new wage code. There might be certain complaints by the employees in case any of the above mentioned factors have not been met. So all these complaints can be made to the appropriate authority, either by the employee or by the trade union in which the employee is a member, or maybe by the ICF. And all these complaints can be made within the period of 3 years from the date of the non-compliance. The appropriate authority is required to address this application within period of 3 months from the receipt of the application. So therefore, the government has tried to provide quick redressal of the grievances of the employees. So 3 month period right now, there is no standardized process wherein the complaints of the employees can be taken up, and there is no timeline that has been defined for the resolution process, but the new labor code provides you the complete timeline within which all the issues have to be taken up. Deduction from the salary. Total deduction in any wage period from wages of the employee shall not exceed 50% of wage of the said month. Now, what this exactly means is that to help you with an example, in many companies wherein they pay when they deduct the TDS on the salary of the employee, they fail to deduct the TDS for the starting 10 months, and they generally compensate the employee by deducting the TDS at the last 2 months of their tenure. Definitely, all the salary that is forming the part of the total remuneration gets deducted in the name of the TDS. Now, with this condition, that total deduction in any wage period from the wages of employee shall not exceed 50%, there will be a limitation that a company can only deduct 50% of the wage amount. So, in case the company has to plan that deduction over the period of year, there cannot be an ad hoc deduction at any period of time. So these are the key features of the wage code that has been highlighted till date. When we talk about the compliances in the wage code, the compliance has considerably been reduced. If you see that at present there are 13 compliances under the Wages Act, which has been made to 4 under the new wage code. When we talk about the Payment of Bonus Act, you can see there are 4 compliance that need to be done. The part 1 being the Form A, register showing computation of allocable resources. Form B, register showing setup of allocable resources. Form C, register showing details of bonus due deduction amount actually paid. And Form D, that is the unified return. So under this act, there was requirement to maintain 3 registers and also was required to file an annual return. Now, under the new code, there is only one form that need to be filed for all these 4 processes. Similarly, for the Payment of Wages Act, there were 1 register that need to be maintained, and there was an annual return. Equal Remuneration Act, there was 1 form that need to be fulfilled, and Minimum Wages Act, there were 3 registers that was required to be maintained. So altogether, the 13 compliances has been boiled down to 4 major compliances. That is to file Form 4, Form 1, Form 5, and only 1 return has been assured by the government. So definitely, when we talk about the compliances under the new wage code, the government has made considerable effort to reduce the compliances on the companies. Moving on to our next slide, that is the penalties and the wage code. Under the penalties, the government has made assurance that the penalty has been increased to the existing labor act. The reason why government has increased the penalties is to make sure that all the companies falling under the ambit of the wage code comply with the compliances. Like there are 4 wages act, as we have already discussed. In the payment of wage act, you can see that in the existing regime, the penalty ranges from 1500 to 7500, wherein under the new code, the maximum penalty has been raised up to 20,000. In the minimum wage act, the existing penalty up to 500. In the new wage code, the maximum penalty has increased to 50,000. So there is a jump of 100 times into this minimum wage act non-compliances. Payment of bonus act, maximum INR 100 in the existing law, and maximum INR 20,000 into the proposed code, that is 20%, 20 times with what we have been paying till date. Under the Equal Remuneration Act, the penalty ranges from 10,000 to 20,000, and under the Code of Wage, the maximum penalty is 20,000. So overall, the Equal Remuneration Act, the penalty remains the same. So in this slide, basically, we have covered all the major parameters that will be applicable to the companies under the wage code. There are 3 other codes as well that has been defined as we discussed in the earlier slide. Due to time constraint, we are not able to take a detailed discussion on that, but definitely we will cover those codes in the upcoming session. Overall, I can provide you with overall review of the comparison of compliances that will be happen between the existing law and the 4 codes that has been proposed. As you can see in the slide, in the existing law, the company is required to maintain 40 registers in comparison to 11 registers under the new labor code. Similar is the case with the returns. The company is required to file 22 returns, wherein in the new labor code, the company will only be filing 4 returns. Licenses 3 in comparison to 2, registration 5 in comparison to 2, and at last but not least, it remains the same, that is 2. Remittance remains the same. Oh, so sorry.
Hi, Niten. Thank you so much for that presentation, and also Deepak. Very insightful, too many takeaways, I'm sure. And I've been seeing the reactions from our audience as well. They've been liking this session. A lot of celebrations, thumbs up, hearts. Thank you for that. And thank you for that active participation. A lot of hearts. Okay, great. Now, I know that, we have we are already at the end of the session, but as promised in the beginning, we want to take some audience Q&A. So we'll try to take as many as we can in the session right now. I'm sure some of the questions might have been already answered in the presentation, but we'll just go through each question now and just have that rapid fire round where we are not going to conclude anything. We'll just, whatever is the fact, we'll answer that question and jump on to the next one. So I am going to take it one by one, either Niten or Deepak, whoever, which one, if you want, you can take any question that you want. So our first question is, our company operates from Karnataka. Our company is expected to submit the POSH annual report to any local authority. If yes, who is it to be submitted to?
Yes, the employer has to submit the POSH return, and I believe that is the Form K under which they have to submit this return, and they have to submit this to the local jurisdictional labor inspectors.
Okay, thank you for that, Deepak. Moving on to the next question. So some questions don't have context. We are going to skip those. But for the rest of the questions, we are going to take up. So another question is, if a business is not required to be registered under the SNE under Karnataka based on the headcount threshold, is it mandatory to take trade license in order to run business?
The trade license is different from SME registration, and this is the permission to do a business. So this depends upon the state regulation, how and where they are requiring the trade licenses. So it depends upon case-to-case basis.
Okay, thank you for that. Next question is from Parveen Nandi. What is BOCW and ISMW?
BOCW means Building and Other Construction Worker Act, and ISME means Interstate Migrant Worker Act. Okay. Under these act, registration is also required.
Right. Next question is from an anonymous attendee. In Tamil Nadu, according to the labor law, is the basic pay 50%? Is it mandatory or not? In Tamil Nadu, according to the labor law, is the basic pay 50%? Like the question, is it mandatory?
Yes. In general parlance, every company is using 50%, and in new labor codes also the 50% criteria is also given for the basic salary.
Okay. Next question is from Ketan Kumar Jain. Under apprenticeship program NAPS, can we pay comp off incentives and OT for these employees?
See, NAPS, NATS under apprenticeship program, they are not employees, they are apprentice. So any benefit which you can give to any employee, you can give any benefit to them.
Okay. Next question is, an organization working in service sector is having 20 plus working staff comprising of 1 contractual staff getting monthly fees after deducting TDS under section 194J. Second, interns and trainees, whether labor law is applicable on such organization.
So, see, the Contract Labor Act applicable if the number of contract labor exceed more than 20. So they have to take a registration under CLRA. And for the trainees are not employees. So, the labor laws are not applicable on interns or, any apprentice because they are not treated as an employee under these labor laws.
Okay. Also, before I go on to the next question, I just want to inform the rest of the attendees that we have a dedicated webinar planned on POSH, which will be conducted on 6th of May. And I would request all of you to stay back because I'll be sharing the registration link for that webinar once we are done, discussing our questions. So stay back. You can, register for that webinar also. We're going to be talking about POSH in detail in that webinar. Okay, next question is from NK. So he's asking if he'll get a recording. Yes, NK, as informed at the beginning to everybody else, we will be sharing the recording of this session with all of you. And this will also be available on greytHR's official YouTube channel under the playlist Parichay. So, you can go and watch it there. Next question is from Siddesh Rao. How does payment of wages work for someone drawing more than 24,000?
If someone are drawing a wages more than 20,000, then this payment of wage act is not primarily applicable on them. Now their entire payment and the deduction will be governed by their employment act, not by the payment of wages act.
Understood. Next question is from Anumeha Raj. What are the categories of the fines allowed to deduct from the salary as per the Wage Act?
So see, house rent allowance you can deduct from the salary. Any advances you have given on account of salary, you can deduct. Any statutory deduction, PF, PSI, PT, LWF, TDS, you can deduct. As far as the fines are concerned, if as per the agreement, it is very specifically mentioned that these are come under the responsibility of, employee. For example, the cash. If the cash is, misutilized, then the employer can penalize that employee. So these are a very specific category of fines which you can impose on an employee.
Okay. Next question is from Mona. Do we have any act for paternity leave benefits in India?
Unfortunately, not.
Maybe in future.
Maybe in future, yes.
Okay. Next question. I am okay. So, okay. So this question is: a new labor law code was hot subject for 3 years now. Are there any chances to implement, or are there any timelines that we are looking at for the same?
The government has to implement these things. Only the pendency with the state governments. And as if now 3 or 4 states are, lagging behind to share their draft rules. So once they share their draft rules, then I don't feel there will be much time to implement these new codes.
Understood. Next, I think a lot of people had the same question as to when it is going to be implemented. So we've answered that. Next question is from Anubhav. In case deduction can't be more than 50% of the wages, how will the FNFs be handled?
If deduction cannot be more than
50% of the wages.
50% of the wages. So
Let
now,
me take this, Deepak. I think here when we talk about the wages, we are talking about the eligible wages. So if suppose the employee has worked for 15 days, then we will only consider the 15 days, and accordingly, whatever the deductions have to happen, it will happen from the eligible wages.
Okay, thank you for that. Moving on to the next question from Ludimer Bernal. I think she's our grade 5 community member also. I recognize her. Thank you for joining us. The question is, for payment of bonus, what is the acceptable percentage for bonus to be given to employees? And if company is not doing well financially, shall they still need to pay bonus?
The minimum percentage is defined under the law, 8.33 of the basic wage. And if the
Okay.
company is not doing financially well, means they are in the losses, then you have to give the bonus out of the profits, surplus. So if there is no surplus, then you are not supposed to give the bonus.
Okay. Next question is from Deepak. So this is a scenario. Hi, Niten. I have a scenario. What if the employee made wrong investment declaration at the month of April, and while submitting the proof of investment, it is found that the employee has not rightfully submitted the proofs. Hence, the total salary is deducted as TDS for 3 months. Now, this is clearly a mistake from employee's end. How can employer take responsibility for paying minimum 50% of salary?
So even if you look into the today's law, the responsibility is on the employer to make certain that all the deductions are being made on the employee salary. So if employee have not provided any kind of declaration correctly, then definitely he has not provided for his deductions and other information. So TDS ratio will anyways will increase in this case. So there will be no point of getting into the last 3 months.
Understood. Okay. The next question is from Ketan Kumar Jain. As per the process, we revise employee salaries to reflect changes in the minimum wage within 3 months of receiving the official notification. And we provide areas for the applicable period. We would like to confirm whether this practice is compliant with statutory requirements or not.
This is from the perspective of the new labor code, I believe. I think this can be done.
Yeah,
This can.
Yeah, it's not an issue.
Okay. Next question is from, okay, so Sameer is asking if you will get the recording, Sameer. You can always, go and watch it again. And in case you have any more questions, we'll share the email IDs of Deepak and Niten, so you can connect with them personally and have those discussions there. Okay, now coming to, I'm just scrolling through. There are a lot of questions on when it is going to be, implemented. So we've already taken that. Now, okay. So there's one question from Gopal Gupta. Why PT slab is different between genders?
Why?
PT slab is different between genders.
No, generally the PT slab is not different. It may be certain state specific law which may, have a different slab. So if we can get the context of that state specific law, then we can answer it.
Okay. So the next question is from Prerna Verma. If there is no child worker in the Factory Act, then we have to display the abstract or not?
Yes, you have to display the abstract. Even the declaration needs to display that no child worker is appointed in this premises.
Okay. Next question is from Suresh Kumar. Will college students be getting stipend during internship? Will be eligible for ESI or not?
Will see, these are not the employees. So these are a training only and working in the company for having a certain training. So they are not covered under ESI, I believe.
Our next question is actually for you. So do you offer, this is an anonymous attendee, however, they would want to understand if you offer labor compliance services in Maharashtra.
Yes, we have our operations there in Maharashtra as well.
Okay. So I'll share the email ID, the person who wants to connect, they can connect with you then. Okay. I think most of these questions we have. So there's one question from Hiral Desai. If a company is based in Gujarat but employs individuals from other states, how should the professional tax be submitted in such a case?
If the company is based in Gujarat,
Yes, but have employees from other states also.
so then PT applicable in the state of Gujarat shall be applicable.
Okay.
Because they are on the muster roll of the Gujarat employers. The employer pertains to Gujarat, then they will be on the muster roll of the Gujarat employer. And accordingly, the PT applicable.
Okay, so I think Raghvendra had a similar question, which is taken care of. I will see if we have. So we'll just take a couple of more questions since we are nearing. We are already, we have already exceeded our time. So I'll just check if we have any more new questions. So, PT. Okay, so quick question from Debashi Das. Could you please explain PT returns state-wise for West Bengal, MP, and Maharashtra?
So as if now we have not readily available with the slabs, so we can share over the email with them.
Sure, sure. So you can, connect with Deepak separately, Debashi, and, you can have that question answered. Just one last question I think I can take is from Naina HR, what is the difference between NAPS and NATS, and which one is more benefited for employer?
See, these are covered under two different ministry. One is Ministry of Education and one is from the Ministry of Human Resource. So these are the two schemes to promote the apprenticeship act. So when we comes to NATS, it's when you are hiring the apprentices after their graduation, then it will cover under NATS and rest other are covered under NATS.
Understood. Thank you so much for that, Deepak and Niten. Great conversation we had today. Of course, a lot of it went into the presentation that you did, which was very, very insightful, as we can see from the response from our audience. And of course, this Q&A also was very informative. As promised, for our audience, we will definitely share Deepak's and Niten's email IDs with you, along with the webinar recorded. So you can, go back and watch it again. Also, in the meantime, I would request Ankita to put down the email IDs of Deepak and Niten in the chat for our audience in case they want to, connect with them right away. They would be able to do that. Also, separately, as I said, if you have any more questions, we have greytHR community where you can connect with us. It's a knowledge sharing platform where we have experts like Deepak and Niten who can help you with your responses related to HR, labor law, compliance. And also we have, as promised in the beginning, the session recording will be shared with you on email. And it will also be there on the YouTube channel, so you can watch it, go back and watch it again. Now, what I'm going to be doing right now is I'm also going to add the registration link of the new webinar on POSH that we are doing. It should be visible to all of you in the chat button. I've just added the registration link. Please, you can click on that and you can go to the registration page and you would be able to register. So that is all from our end. We are also putting Deepak's and Niten's ID as I speak right now. But thank you so much once again, everybody, for joining in. And we had like a great conversation. I can still see questions popping up, but for all the audience, do not worry. We will get back to you on these questions. You can, as we are writing the email IDs of Deepak and Niten in the chat, you can connect with them right now. It's already done. So there's deepak.joshi@ascgroup.in and Niten@ascgroup.in. So please note down these IDs. We are not ending the webinar for another 5 minutes. So you can, have these saved in your inboxes. And at the same time, thank you so much for joining us today. Huge special thanks to you, Deepak and Niten, for such a wonderful presentation and taking us through labor law compliance. It's a very vast and complex topic, but you helped us understand it better and made it more relatable. So thank you so much for your time once again, and we look forward to having you again in the upcoming sessions.
Thank you so much, Rocky. It was really nice being on this platform, and we look forward for same kind of platform going forward. So thank you so much for this opportunity.
Thank you so much, Niten. Thank you so much, Deepak.
Thank you to all for joining the session. Thank you so much.
Thank you, everybody. As promised, we are going to be here for another 5 minutes. There are two things which are added in the chat. One is the registration link for the upcoming webinar on POSH, and the other is the email IDs of our expert speakers today. Please note both down and you can connect with us and have your questions answered if there are any left. Okay, thank you so much once again. I'll go on mute now and we'll keep the tab open for another 5 minutes. Thank you once again, everybody. And thank you so much for joining. Thank you so much, Deepak. Have a great evening ahead.